Hey everybody, this is Tracy here with another edition of A View from Tracy's Point. And as I let you guys know in my community section last night that I did have the motion from Jennifer Bonjean requesting a new trial for Mr. Kelly under the grounds of ineffective counsel. And I told you all that I wasn't going to read it. I was tired last night, had some other things going on. But I just want to give a reminder before I get into this, and this is going to be not so long video because the motion was only like 12 pages long. But this is not a breaking news channel. I'm not in a competition to get the information out. I'm not competing with any other blogger when it comes to putting this information out on this case. I do have a family. I do have other things going on, and I can't just drop whatever I'm doing to jump on YouTube and bring this information to you all, especially like with the prosecution's response to the original Rule 29 and Rule 33 motions. There's like a total of 149 pages or something like that. So that is going to take me some time to get through that. So I can't just put other stuff aside to do this. And then I always keep in mind, my motto is that there are billions of people using YouTube. So whoever is meant to hear my content is meant to hear my content. I'm not in a competition. I'm not in a race trying to be the first one to get information out. And I am so grateful and thankful to those of you who understand that this is not for you. It's for the people that like to send me messages and emails talking about, well, so-and-so is already talking about it. Then if so-and-so is already talking about it, then you've already heard it. So why are you over here trying to get it? Okay. So anyway, just want to let that be known, and we're going to go ahead and get into Jennifer Bonjean's motion, and it will probably be sometime later today before I can get the government's response, because like I said, it was a total of about 150 pages. So this is her motion for a new trial. It says, I, Jennifer Bonjean, an attorney at law, certified that I filed defendant's notice of a supplemental motion for a new trial and memorandum of law in support of the motion via ECF on March 21st, 2022. And let's scroll down here. Oh, and by the way, you guys, weather is beautiful where I live, and I hope you're experiencing the same. Let me scroll down here. Let me know in the comments like what the weather is where you are. I think we are like 80 degrees, a nice breeze coming through. Definitely beach weather. Okay, so she says, introduction. Defendant's trial was engulfed by irrelevant and excessive bad character evidence that added little to the jury's assessment of whether defendant committed the charged offenses. Indeed, the 6-week trial was comprised overwhelmingly of uncharged bad act evidence that served no legitimate evidentiary purpose. With the court's blessing, the government subjected the jury to a mass of repugnant conduct for the primary purpose of depicting defendant as contemptible sexual deviant. The government defended the introduction of the evidence as relevant to the quote unquote means and methods of the enterprise, with nary a word of Rule 403 considerations. For reasons argued in defendant's Rule 29 motion, the government's evidence of an enterprise was insufficient as a matter of law. This case was not about an enterprise. It was about the conduct of one man who the government sought to punish for his alleged history
This case was not about an enterprise. It was about the conduct of one man who the government sought to punish for his alleged history of mistreating women. As such, the mountain of bad act evidence offered in this prosecution was nothing more than inadmissible propensity evidence. Because the defendant was forced to defend against dozens of uncharged claims of abusive and sexual misbehavior, much of it lawful, albeit unpalatable for some, the defendant was stripped of the presumption of innocence and denied a fair trial. Okay, and before I continue, I am going to read to you guys what Rule 403 is. So Rule 403 is excluding relevant evidence for prejudice, confusion, waste of time, or other reasons, and it states the court may exclude relevant evidence if its probative value is substantially outweighed by a danger of one or more of the following: unfair prejudice, confusing the issue, misleading the jury, undue delay, wasting time, or needlessly presenting cumulative evidence. And I think we all can agree that that is exactly what took place with them bringing in all these people who really were just talking about their relationships that were not illegal, okay? And then the things that they did bring in, you know, that could have been seen as illegal, they didn't charge for those. And so that didn't make any sense for me, because like when they brought in Javante Cunningham to give her information, I thought that would have been grounds for some charges, but they didn't bring it in as grounds for charges. They brought it in, you know, for the awe and the wow factor. And then she talked about Aaliyah, but then the things that she talked about were not things that he was charged with the racketeering. And Jennifer Bonjean gets into that later in this document. So picking back up where I left off, it says, but that is not all. Defendant was denied effective assistance of counsel when his attorneys failed to file adequate pretrial objections to the introduction of the mass of overly prejudicial propensity evidence and routinely failed to lodge timely objections to some, although not all, of the damning bad act evidence. And I think we talked about that as I was reading Thomas Farinella, because for the most part, he was the only one that was filing motions, you know, trying to argue some of the stuff that was coming out. And then I told you all, whenever the Calvin Scholar guy filed a motion, it was always under seal, so we never knew what he was talking about in his motions. And so what Jennifer is saying here is that although they tried to file some motions, they weren't targeting the right information. They were basically, you know, putting out objections that were easily overruled. And so in sum, defendant's trial was little more than a reenactment of the one-sided docuseries Surviving R. Kelly, which several of the jurors had viewed before stepping into the courtroom. It is a wonder that the government did not simply offer the docuseries into evidence. With this backdrop, defendant was powerless to defend against the charged offenses, for which there were viable, even winning defenses. Defendant was denied his constitutional guarantee of a fair trial, where the jury heard excessive, minimally probative evidence of contemptible conduct that was introduced solely to inflame the passions of the jury and punish the defendant for decades of unchecked bad behavior. Then she has a section called Relevant Facts. In the 2 months preceding the start of defendant's trial, his defense team was focused on fighting one another and preoccupied with litigating a crucial hearing on account of one of his attorney's disabling conflict of interest. Not surprisingly, defendant's trial team wasted valuable time and resources focused on this side circus rather than preparing a strategy for defending the case. Now, Jennifer gonna come with the jokes, y'all, okay? Now, I expected her, when I posted it in my community tab, that if this motion wasn't giving what I expected it to give, I was kind of talking about like around this part here. Like she didn't get more into how the Curcio hearing impacted the case and the fact that Judge Donnelly allowed Nicole to stay on as counsel even though Mr. Kelly wanted her to stay, we all know that at this point, he's probably so frazzled and confused, like he doesn't really understand, the decisions that he's making. And so it was Judge Donnelly's position to make the right decision, which would have been removing Nicole from the case. And I know a lot of people were telling me, oh, you're giving Nicole a hard time, and she is the right person for the job. But as we quickly saw from the opening arguments, that Nicole was not prepared for this case, and it was just downhill from there, and Canick eventually had to bench her, which was like the only right move it seems that he made throughout the whole trial, was making Nicole sit down and be more of a moral support to Mr. Kelly throughout the trial. So Bonjean goes on to say, at the defendant's request, the court granted an extension for the filing of motions in limine until July 23, 2021. On July 23, 2021, the government filed a whopping 55-page motion seeking to admit a heap of prior bad act evidence. Defense counsel filed no motions in limine. Incredibly, defense counsel failed to preclude any uncharged bad act evidence that was produced as part of the government's 3,500 materials. On July 30th, 2021, defense counsel filed a written objection to the government's motion in limine regarding the introduction of prior bad act evidence, largely on timeliness grounds. The response contained a general objection to the evidence as untimely with no meaningful relevancy objections of Rule 403 analysis. Inexplicably, defense counsel did not seek a continuance of the trial to investigate these alleged quote-unquote surprise witnesses, but merely asked the court to strike them. And then there's a note at the bottom that says this motion was in addition to a separate 39-page motion in limine, docket number 135. And I believe she's referring to a motion that Thomas Farinella filed back in July of last year. And at a final pretrial hearing, defense counsel conceded that he did, in fact, know who the other bad act witnesses were and was familiar with their allegations. Defense counsel conceded that he was in possession of all 3,500 material and had received supplemental 3,500 materials from government. And I believe we talked about that. Like, why are you saying you know who these people are? You know what these acts are? Like, no, we need to get more information. You guys need to be investigating this. And Jennifer Bonjean is saying that's exactly right. Like, they should have asked for more time based on this alone to investigate these stories. And by saying that, it was like they were almost saying that Mr. Kelly agreed with all these allegations that these people were making. And I think that, more important, like the one that Javante Cunningham, that alone should have been argued so that they would throw that out. And I believe that Farinella did file a motion, but once again, it just wasn't a strong motion as to why this information should have been put in. And we talked about the fact that it was hearsay. She didn't have any proof that any of this stuff happened. There was nobody that came along to corroborate her story and say, yeah, that I was there too and I saw what happened. She was able to get up there and just tell story after story after story, and they didn't really challenge her on, any of the information that she was giving out. So Bonjean goes on to say, on August 6, 2021, defense counsel filed a 2-page supplemental opposition to the government's motion to admit other bad act evidence. Throughout trial, defense counsel filed a handful of letters objecting to the introduction of certain bad act evidence. Those objections were largely overruled. The record does not seem to reflect objections to much of the uncharged bad act evidence offered by the government. Then she moves into her argument. And she says, defendant was denied a fair trial when his jury was swamped with a mass of minimally probative, cumulative, and unduly prejudicial other bad act evidence, some of which was admitted without objection in violation of defendant's Sixth Amendment guarantee of effective assistance of counsel. With virtually no limitation, this court permitted the prosecution to inundate the jury with excessive bad act evidence, mostly under the theory that the evidence was relevant to the quote-unquote means and method of the enterprise. The means and method justification for the introduction of copious amounts of bad act evidence is gravely flawed because the government's theory of an enterprise is flawed. Where the enterprise consisted of nothing more than the purported sexual misbehavior of the defendant, unconnected to the activities of a discrete enterprise, the means and methods relevancy justification is meaningless. As argued at length in defendant's Rule 29 motion, the government failed to prove that defendant was distinct from the so-called enterprise. No matter how much repellent evidence of sexual indiscretions or abusive behavior the government accumulated against the defendant, the fact remains that it was the defendant and the defendant alone who engaged in those affairs wholly disconnected to the affairs of a distinct enterprise. By characterizing defendant's purported decades-long history of abusive conduct toward women as an enterprise, the government not only avoided statutes of limitations, but was free to introduce any unkind or abusive act, and then in parentheses she has of a sexual or non-sexual nature, as evidence of the enterprise.
So just to remind you guys of what Rule 404 is, Rule 404 is character evidence, other crimes, wrongs, or acts. 404A is character evidence, and then it has 1, prohibited uses. Evidence of a person's character or character trait is not admissible to prove that on a particular occasion the person acted in accordance with the character or trait. 2, exceptions for a defendant or victim in a criminal case. The following exceptions apply in a criminal case. And then she is referencing B. And so B is subject to the limitations in Rule 412. A defendant may offer evidence of an alleged victim's pertinent trait, and if the evidence is admitted, the prosecutor may 1, offer evidence to rebut it, and 2, offer evidence of the defendant's same trait. So to better understand 404B, its evidence is evidence of prior bad acts that the government. So more on 404B evidence. It is evidence of prior bad acts that the prosecution can introduce in their case in chief under Federal Rule of Evidence, commonly abbreviated as FRE. 404B, the prosecution is able to introduce evidence of defendant's prior bad acts that are not charged in the instant criminal case. Although introduction of 404B evidence is not permissible to show the individual's criminal propensity or predisposition to commit crimes, FRE 404B is admissible for other reasons. And so those other reasons provides that prior act evidence is not admissible to prove the character of a person in order to show action in conformity therewith, but it is admissible for several other purposes. Specifically, 404B evidence can be admissible for purposes such as proof of motive, opportunity, intent, preparation, plan, knowledge, identity, or absence of mistake of accident. 404B evidence admissible in federal court or in state court. 404B evidence is admissible in federal cases. However, New York State has a similar provision, however, under a different name. Under criminal case form from 1901 titled People of the State of New York, the prosecution is able to make what's called a Montague application in its purpose. It is identical to 404B. However, the difference is that 404B comes from a statute, while New York's Montague application comes from a judicial opinion on a criminal case. And it says the prosecutor will make a 404B application as a motion in limine before trial. The reason why a 404B application is made before trial is to give both sides an opportunity to present their arguments to the judge as to whether this 404 evidence should be presented at trial. And so basically what Bonjean is saying is that defense counsel did not fulfill that duty, or didn't fulfill it to the extent that it should have been. So back to her motion. So she goes on to say, notwithstanding, this court was still obligated to conduct a meaningful Rule 403 analysis, which it failed to do. Rule 403 authorizes the exclusion of relevant evidence when its probative value is substantially outweighed by the danger of unfair prejudice, confusion of the issue, or misleading the jury, or by considerations of undue delay, waste of time, or needless presentation of cumulative evidence. The United States Supreme Court held in Old Chief that unfair prejudice as to a criminal defendant speaks to the capacity of some conceitedly relevant evidence to lure the fact finder into declaring guilt on a ground different from proof specific to the offenses charged. Old Chief versus United States, which was a case from 1997, the committee notes to Rule 403 explain, unfair prejudices within its context means an undue tendency to suggest decision on an improper basis, commonly, though not necessarily, an emotional one. And then it goes on to say, advisory committee's notes from 403, as Old Chief observed, courts that follow the common law tradition almost unanimously have come to disallow resort by the prosecution to any kind of evidence of a defendant's evil character to establish a probability of his guilt. Not that the law invests the defendant with a presumption of good character, but it simply closes the whole matter of character, disposition, and reputation on the prosecutor's case in chief. The state may not show defendants prior trouble with the law, specific criminal acts, or ill name among his neighbors, even though such facts might logically be persuasive that he is by propensity a probable perpetrator of the crime. The inquiry is not rejected because character is irrelevant. On the contrary, it is said to weigh too much crime with the jury and to so over-persuade them as to prejudge one with a bad general record and deny him a fair opportunity to defend against a particular charge. The overriding policy of excluding such evidence, despite its admitted probative value, is the practical experience that its disallowance tends to prevent confusion of issues, unfair surprise, and undue prejudice. And that was Mickelson versus United States, which was a case heard in 1948. Probative value is also informed by the availability of alternative means to present similar evidence. Specifically, the Supreme Court has advised that the Rule 403 probative value of an item of evidence may be calculated by comparing evidentiary alternatives. And that was also from the Old Chief case. The district court is afforded wide discretion to exclude evidence that is on balance unduly prejudicial. And that's from Tavares, and that was heard in Eastern District of New York in 2006. And they were quoted as saying, so long as the district court has conscientiously balanced the proffered evidence's probative value with the risk for prejudice, its conclusion will be disturbed only if it is arbitrary or irrational. And then Bonjean goes on to say, as set out below, this court did not conscientiously balance the probative value of certain proffered government evidence that carried an extraordinary risk of prejudice. In some instances, trial counsel failed to object to the introduction of such evidence, rendering counsel's performance objectively unreasonable. A. Excessive STD evidence. The government charged the defendant with committing numerous racketeering acts in the states of California and New York by knowingly exposing Jane and Faith to herpes. This court repeatedly noted that under its interpretation of the statutes, the government was not required to show that defendant transmitted herpes to Jane and Faith. Mere exposure was sufficient. And for those of you who don't know, Jane is Ariel Clary and Faith is Faith Rogers. As set forth in his Rule 29 motion, defendant quarrels with this court's interpretation of the statute, but assuming arguendo the court is correct, there is little justification for allowing massive amounts of evidence that defendant purportedly spent decades transmitting herpes to numerous women. Through defendant's position, the government presented evidence that defendant had herpes when he was sexually active with Jane and Faith, that he knew he had herpes during the relevant time period, and that he was treating his condition with a regimen of Valtrex. Both women testified that they had unprotected sex with defendant, and that defendant did not disclose that he suffered from herpes. This evidence went unrefuted. Accordingly, any additional evidence related to defendant's herpes diagnosis and transmission of herpes to other women was unnecessary, cumulative, and unduly prejudicial, regardless of relevance. Notwithstanding, the prosecution admitted excessive evidence about defendant's failure to practice safe sex and elicited numerous allegations that defendant transmitted herpes to other women. Specifically, the prosecution presented testimony that defendant, 1, suffered from other sexually transmitted diseases prior to his sexual relationship with Jane and Faith, 2, had infected Geronda with herpes, 3, had infected Kate with herpes, and 4, had infected Anna with herpes. The prosecution offered copious amounts of documentary evidence regarding defendant and his partner's herpes treatment and elicited graphic details from multiple witnesses about the symptoms of herpes. The government uttered the word herpes hundreds of times throughout this trial. This evidence was rank propensity evidence. For the reasons argued in defendant's Rule 29 motions and above, the government simply failed to show that the so-called enterprise existed so that defendant could expose women to herpes. As such, the herpes evidence is not justified under the catch-all means and methods of the enterprise. It's just propensity evidence. Moreover, whatever probative value it had was significantly outweighed by its prejudicial effect. And she also should have added in here the fact that it didn't appear that the defense counsel subpoenaed the medical records of any of the Jane Does to determine when in fact they were diagnosed with it. And then we also had people, I believe it was Kate, who said that even though she sued him and received a settlement, she still wanted to have a relationship with him, and he refused to see her again after that. And so none of that really was argued or they went on about that to show that how was this criminal when she still wanted to be with him. So Bonjean goes on to say, although trial counsel voiced an objection to the admission of Kate's testimony, the record does not clearly indicate that trial counsel objected to the excessive amount of herpes evidence from numerous other witnesses. This failure was objectively unreasonable since there is no possible trial strategy for failing to limit this type of other bad act evidence, which was designed to breed contempt for the defendant. Furthermore, there can be no confidence in this verdict of guilt where it was based largely prejudicial bad act evidence, including excessive herpes evidence. And then B, evidence concerning sexual relations with Aaliyah. The prosecution charged the defendant with one racketeering act of bribery for the sole purpose of getting evidence before the jury about his marriage and relationship with Aaliyah. Over defense counsel's objection, this court permitted the prosecution to introduce testimony from Angela, which was Javante, Jane Doe number 7, that she allegedly observed sexual interactions between defendant and Aaliyah in 1991 on defendant's tour bus. This court erred by allowing this highly prejudicial testimony into evidence. Angela's testimony was not relevant under the means and methods theory since it purportedly occurred pre-Enterprise. This court seemed to recognize this fact, but nonetheless concluded that Angela's testimony that she witnessed sexual interactions between defendant and Aaliyah provided the motive for defendant's racketeering act of bribery. Defendant respectfully disagrees on this point. The prosecution presented testimony about defendant's alleged motive for marrying Aaliyah through Demetrius Smith, who expressly stated that defendant told him that Aaliyah was quote-unquote in trouble and that quote-unquote thought she was pregnant. Smith elaborated that defendant believed that he needed to marry Aaliyah to protect himself from going to jail. Graphic testimony from a third party about seeing defendant and Aaliyah engaging in sexual relations added nothing more to the motive than defendant's own admissions that the fact that he married Aaliyah. Whatever probative value Angela's testimony had on this point was substantially outweighed by its prejudicial effect. As such, it was error to allow Angela to testify about her alleged observations on the tour bus in 1991. C. Testimony from Addie, Alexis, Kate, Anna, Angela, Lewis, and Alex. This court permitted the government to present a whopping 7 additional witnesses to testify about graphic, uncharged bad act evidence concerning dozens of sexual encounters with the defendant. Apart from Angela's testimony, which concerned sexual conduct pre-Enterprise, the prosecution defended the introduction of this evidence under the catch-all means and methods of the Enterprise theory. As argued above, where the defendant and the defendant alone was the Enterprise, the means and methods justification for the introduction of copious amounts of bad act evidence is simply a free pass at introducing unlimited bad act evidence related to defendants' alleged sexual misdeeds and abusive conduct. The circular logic returns us to the overarching defect in this prosecution, namely that it was a prosecution of defendant's bad character and unpunished sexual misdeeds. It had nothing to do with punishing or preventing the conduct of the enterprise. Even if the evidence had some relevant purpose, the evidence was cumulative and unduly prejudicial. The jury was inundated with one jarring story after the next of unconventional graphic sex acts, including sexual conduct that many, perhaps most, would consider deviant. Example, group sex, elements of BDSM, and coprophilia. When considering this mass of prior bad act evidence, cumulatively, its probative value is diminished exponentially as compared to its prejudicial effect. There can be little doubt that defendant's jury was inclined to rectify past injustices by punishing defendant even if it harbored doubt about his guilt on the charge of the offense. The risk of prejudice and confusion was particularly acute where the trial developed into a live rendition of the surviving R. Kelly docuseries, replete with viewings of sexually explicit videos. Trial counsel objected to the introduction of testimony from Addie in a letter dated August 26, 2021, filed under seal, but the record does not seem to reflect the defense counsel specifically objecting on 401 or 403 grounds to all of the aforementioned prior bad act evidence with the exception of Angela, but only as to her observations about defendant's conduct with Aaliyah and not as to her own sexual experiences with defendant. Is that not what we've been saying all along? Trial counsel's performance was objectively substandard where it failed to adequately object to the introduction of this damning evidence. Trial counsel offered no written response to the prosecution's motion to allow this evidence and made no meaningful arguments at the final pretrial conference on these matters. Since trial counsel claimed that he was surprised by the proposed other bad act witnesses, he was in no position to make cogent or comprehensive arguments objecting to this unduly prejudicial evidence. Even when given another opportunity to file more fulsome objections, counsel failed to do so. No trial strategy justifies this objectively unreasonable performance. Strickland versus Washington, which was a case in 1984. And then she has notes at the bottom where she gives the definition of BDSM as sexual activity involving such practices as the use of physical restraint, the granting of relinquishing of control, and the infliction of pain. And then corporophilia, marked interest in excrement, the use of feces or filth for sexual excitement. Inexplicably, and this is her continuing on, trial counsel affirmatively introduced other prior bad act evidence. For example, trial counsel opened the door to testimony concerning defendant's prior criminal prosecution in Illinois State Court related to sexual exploitation. No sound trial strategy justified telling the jury that defendant had been previously prosecuted for crimes nearly identical to those charged in the instant case. Defendant was prejudiced by his attorney's failings, where a reasonable probability exists that this court would have excluded much of the prosecution's proposed bad act evidence if it had been challenged competently. There can be no confidence in this verdict of guilt where the jury was overwhelmed with bad character evidence. D. Admission of graphic videos depicting sex acts. Defendant was further denied a fair trial when the court permitted the introduction of graphic pornography and still photos involving group sex between the defendant, Alex, and Dominique, who did not even testify in these proceedings, and graphic videos involving Anna, including a video depicting coprophilia. Trial counsel objected to the introduction of these videos, albeit belatedly, again for the reasons set forth in counsel's letters to the court and for the reasons identified supra, was evidence was not relevant to any means and methods of an enterprise, since there was no enterprise. Whatever probative value it had was substantially outweighed by its prejudicial effect. One cannot imagine a more prejudicial piece of evidence than these videos, which added very little to the testimony the jurors heard. Conclusion: in light of the foregoing, defendant's convictions must be vacated and a new trial ordered. Respectfully submitted, Jennifer Bonjean Law Group, PLLC. Okay, so you guys, when I made my post on the community chat, I stated, this wasn't giving me what I expected it to give. And I still feel that way. However, she did make some very valid points, but I kind of would have preferred her to have gone into more details. But I'm sure she's saving, if Dunley denies the motion, she's probably saving a whole lot of material for when she goes before the appellate court. And so I can kind of understand it, but she did make some good and valid points in this motion, so I will give her that. So I am going to go ahead and let you guys talk about it in the comments. Let me know your thoughts, and then I am going to prepare for these 150 page documents. And since I am watching my new little grandbaby, I am going to wait until after his father comes to pick him up when he gets off from work before I start recording that video, because I don't want any interruptions. So that's it for me on this one. Go ahead, leave your comments below, rate the video, and subscribe to the channel if you haven't done so already. And until the next time, I shall talk to you guys later. Bye bye.